in select committees. The application is therefore declined. I call on Government Order of the Day number 1.
Lawyers and Conveyancers Amendment Bill, third reading.
The Honourable Chester Borrows.
Thank you, Mr. Speaker. Mr. Speaker, I move that the lawyers...
Point of order, Charles Chevelle.
Mr. Speaker, how is it in order for the Minister responsible for the bill to walk out of the House before you give the call and then to have a substitute Minister be responsible for the carriage of the third reading?
It's not a bad point the member raises, and that is sloppy performance. There's nothing wrong with another minister taking charge of a bill. However, the minister responsible for the bill should not be in the House at the time. If the minister Now we need to sort out what is going on here. If the minister responsible for the bill is going to take the call, I'll call the Honourable Judith Collins.
Thank you, Mr. Speaker.
The Honourable Judith Collins.
Mr. Speaker, I move that the Lawyers and Conveyancers Amendment Bill be now read a third time. The Lawyers and Conveyancers Amendment Bill amends the Lawyers and Conveyancers Act 2006. It's wonderful to be so wanted by the opposition to constantly be here, and I have to say the Lawyers and Conveyancers Bill is an excellent bill to be able to remind the opposition that this Parliament is, in fact, this government's brought to Parliament a bill that has been asked for by the profession. Part 1 of the bill restores the title of Queen's Counsel to the office currently known as Senior Counsel, and in general restricts eligibility to that rank to barristers in sole practice. The first New Zealand appointments of Queen Counsel were made in 1907. From 1915 to 2008, each Queen's Counsel was required to practice as a barrister sole. In the Government's view, the restoration of the title to Queen's Counsel reflects the public purpose and the status of this position, while the return to a key eligibility criteria practice as a barrister sole protects the independence and objectivity of Queen's Counsel. Those people who were appointed Senior Counsel in 2008 may return that title or convert to the title of Queen's Counsel. In addition, Senior Counsel and Queen's Counsel may continue to practice their practice arrangements, including practice as a partner in a law firm established between 2008 and the commencement of this legislation. They will not be required to change to practice as a barrister sole. The bill also preserves the power to appoint other lawyers, including litigators and law firms, as Queen's Counsel in recognition of extraordinary contributions to the field of law. Mr. Speaker, Part 2 of the bill contains a number of comparatively minor technical amendments to the Lawyers and Conveyancers Act. These amendments cover incorporated law firms and conveyancing practices, address the circumstances for the exercise of a power of attorney that could arise when a sole practitioner is an undischarged bankrupt, and clarify the time requirements for lodging an application seeking a review of the decision of a Standards Committee by the Legal Complaints Review Office. During the Committee of the Whole stage, 5 further amendments were added to Part 2 of the bill. Most of these amendments address improvements proposed by the Chairperson of the Lawyers and Conveyancers Disciplinary Tribunal, and I thank the Tribunal for these proposals. The additional amendments to the provisions for the Disciplinary Tribunal clarify that lawyers who surrender their practising certificate during a complaints procedure continue to be subject to the disciplinary regime of the Act, streamline the notice requirements for decisions on complaints, while ensuring relevant parties are given notice of these decisions, and reduce the quorum from 5 to 3 members when considering interim name suppression applications. A separate amendment enables the Dean of the Law School at the Auckland University of Technology to join the Deans of the other law schools as a member of the Council of Legal Education. This is a welcome addition to the Council. The Justice and Electoral Committee received and heard 6 submissions from professional organisations, interested groups and individuals. I thank the submitters and also thank the Justice and Electoral Committee for their examination of this bill. Mr. Speaker, this bill has received quite a lot of condemnation from members opposite, based really on the retention or the return to the name of Queen's Counsel. This is actually a move that has been made because, in fact, the profession has asked for it. I have to say that when the change was first made to senior counsel by the previous Labor government, that was done despite the concerns of the profession at the time. In fact, it was a petty and childish change which the previous Labor government thought was part of their Republican movement. Frankly, nobody else cared about it except the people who had the office, the Queen's Counsel, who took their position and their obligations very seriously. They didn't ask for it to be changed. This government has listened to it along with other parties in the House who are supporting this bill. And what we have said is that actually there is something much greater and more important here. And one of the parts of that is so important is that actually the Queen's Counsel must be independent. They must be independent from firms wherever possible. Of course, there is a grandfather or grandmother clause in this particular situation. And that is because every small law firm, every small litigant, everyone who is not a big corporate client should be able to access the very best legal representation they can. And quite often that is going to be found with the Queen's Counsel. It should not be the preserve of only large law firms to be able to get in the best legal counsel. Every small litigant should be able to access it, no matter how or where they come across it. They shouldn't have to all go to big law firms to get the legal advice they need. I understand that some members might think that it's all right to have only big law firms who can access the top legal providers. Well, I don't think it is, and nor does this government. It is part of access to justice to have the Queen's Counsel independent from firms, so that in fact every litigant should be able to get the very best professional advice they can, rather than to have to go through a big law firm. And the member, Mr Chevelle, says that lawyers are charging at $900 an hour as Queen Counsel. Well, actually, that's true. There's also lawyers who are doing work pro bono as Queen's Counsel, and they do. And I'm sorry that Mr Chevelle doesn't think they do. But actually, big law firms also do that. Many big law firms will charge at that rate for particular work. And in fact, Mr Chevelle says, how would I know? Well, of course, I understand that's how Mr Chevelle liked to charge when he was in a big law firm, so he should know well about that. And anyway, he says nobody complained about that. Well, I'm not so sure, and I'm sure there's the odd department around that might be able to find the odd complaint that they might have. And I see a former member of Corrections sitting over there and laughing, and so she should too about it. But Mr Chevelle has rights to raise these points, but actually this is not the way in which to bring about republicanism. Make sure when we make changes to institutions and that we're actually doing so for a good reason. And I'd say to Mr Chevelle, what a childish thing to do, to come down to the House and say we have to change the name because it's going to become more of a republic. What a silly thing to do. And actually, what about the tradition of law? Why is it that only some traditions are sacred? How about other traditions? Next thing, it's trying to get rid of the prayer in Parliament because people want to change the tradition. How about traditions in other cultures? Do we do that? No, we should respect them wherever we can. But actually, having said that, I think that Mr Goff's right. People should live up to the words in the prayer as much as they can, and I'm sure that he wants to be able to do that now. But anyway, Mr Speaker, I commend this bill to the House. I thank the parties who are voting for this bill. I thank the Select Committee for it. I think this is a good bill. The profession will be very pleased with it. They've said to me that they've been looking forward to this. They want to make sure that the independence of the bar and the independent bar is maintained. They were very concerned that it was going to be put at risk by the fact that only big law firms would be able to access the best and the brightest, and to be able to get that work or that assistance for their corporate clients. I think it's important. It's an access to justice issue, and I commend the bill. I believe it's an extremely important proposition to have, is that all clients or all litigants should be able to get the best. They shouldn't have to go through big law firms and put up with the outrageous fees that I've seen coming from them.
Just before I call the next member, I'd just like to advise members that electronic